Welcome back to Speak Van Holding 247, etc. If you like, subscribe and share with your friends. Today I'm going to discuss you and your attorney. Whether you hire an attorney or the court appoints you an attorney, a contract is created. A lot of people think when the court appoints them attorney that they are not in a contractual relationship. By virtue of the attorney fiduciary duty, when a court appoints you an attorney, a contract is generated once you accept that appointment of counsel. There are two things common with a court appointed attorney or whether you hire one. They don't like to return your phone calls. And another thing common with them, they do not really want to protect your interests. I'm going to show you how to protect your interests when you're dealing with an attorney. Anytime you want to communicate with your attorney, it is very important to never call your attorney. Always use a certified mail return receipt or just plain certified mail, this is very sufficient. They each have unique numbers. Whenever I want to communicate with an attorney or if I want to write a business or an entity or a governmental agency, I set a slip aside because they have unique numbers. I take a slip. You can get these at the post office, they're free. Try to get you 15 or 20 of them at one time when you go. I take this and I put this very number on my letter when I finish. I type it at the end of my letter. I take this very slip to the post office and say, use this particular letter, this particular receipt, certified mail with this letter. And I track it. When it gets to its destination, I download the tracking information on the tracking. When I look it up, put it in my Google Drive or print it out. This is for my records to show they received the letter. The reason why you want to communicate with your lawyer through certified mail because you don't have a track record of when they call you and they don't call you. When you are charged with a crime, it is imperative that you write your lawyer and tell him to conduct formal discovery. You be explicit. If you have a witness, you get that witness name, address, and phone number. Also, if you but you want to inform that attorney to conduct formal discovery, meaning you want him to ask for a Brady list, or it's also called Giglio list, of all the officers that are untrustworthy. A Brady and Giglio list is compiled by a prosecutor of each state of police officers that are untrustworthy, have criminal misconduct while working in a police capacity. The reason why you want this list is because a lot of these attorneys that arrest you, fill out the report, they have been shown to lie, falsify documents, falsify statements. You need that to defend yourself because this ensures that you get a fair trial. A lot of time the prosecutor won't put certain officers on there. And a lot of time they will react it to remove certain officers depending on your case to try to trip you up. But you still ask for this here through formal discovery. You also ask for any and all witnesses that the state intend to use, any and all experts that the state intend to use. You write your lawyer and tell him to file formal discovery for this and do it within 45 days and to provide you with the discovery and sit down and discuss it. When you do this here, you're going to know that your lawyer will be more receptive to you. But what happens when you send this certified letter requesting your attorney to do this, the attorney going to try to call you. Well, you can answer his call, but like you said in that letter, you let him know if he can't communicate you through certified mail, he needs to ask the court to reappoint a counsel, because the reason why that attorney don't want to communicate you through certified mail, because he knows that the minute he writes you telling you he's not going to conduct formal discovery, he done violated the fiduciary duty and you can sue him. And he could lose his license. He know this. But he'll tell you through the phone, oh, I'm not going to do that. But you can't prove he said that. This is why you want to write him. Now, from the time that you are arrested, you also write your lawyer and tell him to demand a speedy trial. Write your lawyer when you ask for him to conduct formal discovery. This is very important. This is some basic stuff that if you don't know, you know now that you can do to help yourself. The reason why you need to do this here because when you fail to do this here, your chances of conviction increase by 100. When you do this here, your chances for conviction decrease by 10%. Now, once your lawyer get that certified letter asking him to conduct formal discovery, let me back up with that formal discovery. You be explicit. You want the Gigolo and Brady list from the prosecutor or the police. You want him to do a deposition of all and any witness that the state intend to use and call against you, as well as the experts. You want a list of name of all the witnesses, experts that they intend to use, and any evidence they intend to use. Just tell your lawyer you request it. This is very important. This is 88% of your case in defense. When your lawyer get it, trust me, he's going to call you. He's going to try to convince you, he can't do this and this and that. If your lawyer call you and tell you he can't do this, you're not going to do this. You turn around and send him another certified letter informing him, hey, you called me, you told me this here. You say you wouldn't do this here, you say you wouldn't do this here. I'm asking you to withdraw yourself because you are being ineffective as a counsel. And you have breached your fiduciary duty to me, and I don't trust you. Should you fail to withdraw from the case, I'm going to file a state bar complaint against you. Even if he do withdraw, you file a state bar complaint with the State Bar of Texas, spelling out his refusal to protect your interests. This is a very powerful tool. A lot of people don't know that you can complain to the State Bar of Texas who give them their license. They have the ability to strip them of the license and suspend the license, and they will do it. Now, when you do this here, you're going to find that the judge going to be mad at you, the prosecutor going to be mad at you, but at the same time, they're going to be afraid to try to just mess you over because they understand you're putting protection on yourself. Now, you get another lawyer trying to do the same thing, you do the same thing. Tell me you do the same thing. Because, see, it's up to you to protect your interest to a fair trial. They know you don't know the law, so your attorney is more willing to mess over you and go along with the prosecutor so the court can keep sending them send them cases their way for court-appointed defendants. That's how they get paid. So they rather stay in the good graces of the court. Now, once you do that, you start asking your attorney, let's say you're innocent, you're actually innocent. Hell, even if you're not innocent, you want to sit down and say, hey, what evidence they have? Sometimes your lawyer tell you, well, let me back up. When I first got in trouble with the law, it wasn't the first time, but the court appointed an attorney. And I remember sitting in the jail, the attorney came and say, I still remember this to this day. He said, oh, Mr. Simmons, they got you. Oh, they got you. And I'm just looking at this motherfucker. I said, you're a goddamn lie. You too enthusiastic about this shit. Oh, they got you. But the prosecutor said they offering you a deal. I said, what's the deal? They said, tell them I want a jury trial. They're going to have to prove that. I knew they couldn't prove it. Now, I'm not telling you I was guilty or I'm not guilty. I'm just saying I knew they couldn't prove it. The burden is on them. So come on with it. I'm not going to help you capture me. I'm not going to help you kill me, okay? I knew they couldn't prove it. She said, Mr. Simmons, you go to jury trial. I said, man, I don't give a damn. Bring that shit on. Next thing you know, case dismissed. See, I didn't know the law did. I just knew one thing. If you saying I did that, and I know I didn't do that, and I know I did do that, but I know you can't prove that, I'm not going to help you get me. Oh, hell no. So, you have to understand a lot of games they play to get you. And because you don't know the law, you're at a disadvantage. See, a lot of people go, I know my rights. You see them with the camera on YouTube. They telling the police, I know my rights. No, they really don't know their rights. Because they can't go up in that courthouse, file the proper motions, defend themselves, They can't do it, okay? They just, merely going through the motions. When it come to me, I have actual judgments against attorneys that I beat. I got a take nothing judgment against an attorney represent somebody, and I got a no evidence summary judgment awarded in my favor against an attorney who was representing someone. When I filed these motions, they did not expect me to file them. They did not expect me to know it. But after reading those documents, they was firmly, the judge understood, even when it became, let me explain something to you. When those motions came before the judge was really upset because I knew what I was doing. So the judge kept trying to not grant the motions till I just started yelling at the judge. And I just told the judge, look, you trying to help, okay? You are trying to make an argument for counsel where the counsel has not even argued. So I'm telling you is this. When dealing with the no evidence summary judgment motion, I say they don't have no evidence of a valid contract that I entered into, that I agreed to. They don't have a valid contract. And so the judge kept saying, well, where in the rule does it say I have to grant your motion if they don't come with evidence? I say, Your Honor, this motion been sitting at your desk for 2 months. I cited the case law in the rulings, cited the case law in the rules in the motion. And I say, you see what the law say. And I just told the judge, you upset because you haven't seen someone like me able to do what I do. And you upset at my audacity to come up in this courtroom and represent myself and do it quite well against an attorney who is trying to commit fraud against me. And I told the judge, you are not going to commit fraud against me. You can either grant it or deny it. She granted it. Now, see, a lot of people get up in the courtroom and they're afraid to speak. The courtroom is for the people, and that's where you need to speak. Now, I'm going to close this video because I'm very tired, but at the same time, I hope you have learned how to put protection on yourself when you communicate with your attorney. So without further ado, I'm going to dismiss you for the day, and I'm going to finish my bourbon. That is very good, just like my legal skills. Don't hate me, hate yourself.